Election and contract law, Australia, Hong Kong, and China compared.
选择权原则与合同解除的比较研究。
A comparative study of the option principle and contract termination. I became interested in this topic after reading an open access article titled, Election Defined by Matthew Fry, Oxford Journal of Legal Studies, 2026, and a related reference, Rethinking Election, a general theory by Chao Liu, City University of Hong Kong School of Law 2014 SSRN. Today we turn to one of the most structurally elegant and conceptually demanding doctrines in contract law, the doctrine of election. In Chinese, we might translate this as
选择权原则
option principle, but that translation is deceptively simple, because what election truly represents in common law is not merely choice, but a binding choice between inconsistent rights, in Chinese,
相互矛盾的权利
conflicting rights, and once that choice is made, it is binding, it is irrevocable.
选择已经做出极具有约束力。
Today we examine this doctrine across three legal systems, Australia, Hong Kong, and mainland China, and we ask a fundamental comparative question. Is election a universal structural necessity of contract law, or is it simply a distinctly common law construct? Part 1 Australia. The structure of election. In Australian contract law, election most commonly arises after repudiation. Repudiation in Chinese can be expressed as
根本违约
fundamental breach,
预期违约
anticipatory breach. Repudiation occurs when one party demonstrates, by words or conduct, an unwillingness or inability to perform essential obligations. At that moment, the innocent party faces a choice, and this is where election begins. The innocent party may 1. Affirm the contract.
确认合同继续有效
The contract remains valid, or 2. Terminate the contract.
解除合同
Termination of contract. These rights are inconsistent. Why? Because affirmation treats the contract as continuing. Termination treats it as ended. One cannot logically do both, and this proves to be the essence of election. The three elements of election. Australian courts generally require three elements. 1. Knowledge of the facts.
知悉违约事实
Knowing the facts of the breach of contract, the innocent party must know the breach. 2. Knowledge of the right.
知悉解除权
Knowing the right of termination, the party must know they have the right to terminate. 3. Unequivocal conduct.
明确无误的行为表示
Unambiguous expression of behavior. Conduct must clearly indicate the choice. Silence alone rarely suffices, but by continuing to perform, such behavior may amount to affirmation. Affirmation holding the contract alive. Affirmation.
合同继续履行的选择
Option to continue performance of the contract keeps the contract on foot. The parties remain bound. Future obligations remain enforceable. But here is the subtlety. Even if the innocent party affirms, they may still claim damages. Chinese
损害赔偿
damages. Affirmation does not waive damages for past breach. Termination. Accepting repudiation. Termination requires communication. In common law, the innocent party must accept the repudiation. In Chinese,
接受违约并解除合同
accepting the breach and terminating the contract. Termination releases future obligations, but preserves
既得权利
accrued vested rights. Election and waiver. Election is distinct from waiver. Waiver.
权利放弃
Waiver abandons a right. Election chooses between rights. Common law offers two paths, believes Fry. The main claim is that an election is a choice between mutually exclusive powers, the effect of either of which is to destroy the other. One power, the power to rescind, to terminate, changes the power holder's legal relations with respect to another by destroying a primary set of rights, and the other power, the power to affirm, destroys the former power without affecting any pre-existing set of primary rights. Frey 2026. 1. This structural distinction is deeply embedded in common law thinking. Part 2 Hong Kong. Common law in bilingual form. We now move to Hong Kong. Hong Kong maintains a common law contract system. Its highest appellate court is the Court of Final Appeal. Crucially, Hong Kong judgments are bilingual. This allows us to see how election doctrine is translated into Chinese legal vocabulary. How Hong Kong expresses election. Hong Kong courts frequently use language such as
选择是否行使解除权
literally, choose whether to exercise the right of termination. This is election, though the phrase
选择权原则
option principle is not always formally invoked. The structure is unmistakable. Hong Kong judgments also refer to
接受违约
accept repudiation, accepting the breach of contract,
确认合同继续有效
affirm the contract remains valid,
不得做出与解除权不一致的行为。
Must not act inconsistently with the right to terminate. No actions may be taken that are inconsistent with the right of termination. This last phrase is especially revealing. It reflects the doctrine of inconsistent rights, the role of scholarship. Scholars such as Chao Lu have examined anticipatory breach and termination in common law contexts, including Hong Kong. Anticipatory breach.
预期违约
Anticipated default. His work underscores how the right to terminate arises only when repudiation reaches sufficient gravity. Thus, election is not merely procedural, it is structurally linked to seriousness of breach. Part 3. Mainland China. A different structure. Now we move to the People's Republic of China.
中华人民共和国
The governing instrument is the Civil Code.
民法典
Does China recognize a doctrine of election? Not formally. There is no explicit
选择权原则
option principle in the common law sense, but functionally similar mechanisms exist. Remedies under the Civil Code. The innocent party may
要求继续履行
demand, request continued performance,
解除合同
terminate contract,
请求损害赔偿
claim damages. At first glance, this looks similar, but structurally, Chinese law does not conceptualize these as mutually exclusive inconsistent rights in the same doctrinal framing. For example, a party may terminate and still claim damages. In common law, termination also allows damages, but the framing is binary. Affirm or terminate, one or the other. Chinese law tends to emphasize coordination rather than a framework of exclusivity. This reflects a set of broader principles.
公平原则
Principle of fairness,
诚实信用原则
principle of good faith, principle of honesty and trust. Part 4. Structural comparison. Let us pause and compare. In Australia, election is central. It is doctrinal. It is exclusive. In Hong Kong, election is applied faithfully. Its language is bilingual. Its structure remains common law. In mainland China, remedial choice exists, but not as a doctrine of inconsistent rights. The contrast reflects deeper jurisprudential commitments. Common law prioritizes
法律确定性
legal certainty. Civil law prioritizes
救济协调性
coordination of remedies. Final reflection. So what have we learned? Election in common law is not merely a choice. It is a structural safeguard of logical consistency. One cannot both affirm and terminate. One cannot treat the contract as alive and dead at the same time. Hong Kong demonstrates how this doctrine can be translated, linguistically and conceptually, into Chinese without abandoning its structure. Mainland China demonstrates a different model, remedial pluralism rather than binary election. And perhaps this reveals something deeper. Common law insists on exclusive pathways. Civil law tolerates coordinated remedies. To conclude in Chinese,
普通法通过选择权原则强调权利之间的排他性，而中国民法典则强调救济方式的并存与协调。
common law emphasizes exclusivity between rights through election. Chinese civil law emphasizes coexistence and coordination of remedies. And that difference, subtle yet profound, is what makes comparative law an interesting, a rewarding exercise. Stay connected.